Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Now, the question then arises, is this sexual union a marriage? That's what we've been debating, for the last an hour or so.
It was the third?
Is this sexual union akin to a marriage? If it is akin to a marriage, is it founded in any provision of the Constitution? Next question. And then the third, for it to result in certain rights, it can only be done through recognition by the state, through legislation. There can't be a declaration to that effect.
Constitutional perspective, the constitutional lexicon.
Yes.
When you say can't,
Yes.
the can't has to also fit into some constitutionally recognized prohibition.
Yes. Which
You
is,
would say
that it's a regulatory exercise of rights, ultimately have to be regulated.
No, that-
Regulation can only be done through law.
No, that's right.
Yes.
That's part of regulation. We are on a more fundamental path.
Yes.
Declaration.
Yes.
Well, we have now evolved to the extent of understanding what are constitutionally manageable standards,
Yes.
existence of it, non-existence of it, matters which are not to be gone into the court by the court, etc. Where would you locate that? When you say a prohibition is prohibited.
Manoj,
The
I tell
declaration
you,
is prohibited.
moment your lordships decide that this union is a marriage, in what context will you decide that, Manoj? Ultimately, what is a marriage? The marriage is only a union.
No, forget the issue of whether the court should declare this to be a marriage.
Yes.
We are now on the core issue as whether the court can issue a declaration.
That it's a marriage.
No,
that is a union.
That the court can issue a declaration.
A declaration qua what, Manoj? That it's a sexual union. That's all, Manoj. It can't be doing anything
Yes,
more
you're
than that.
right. See, there is no declaration in vacuo or vacuum.
No, Manoj, there can be, Manoj.
Of course, you're right, but see that the court has in its repertoire a right to declare right from 1960, Justice Subbarao, I think that Kochuni onwards is there. Question is, what is that declaration we have to issue? Will it be marriage or not marriage or something?
No, that's right. That is the question that, Manoj, I'll try and address your lordships on, but that's the really core issue.
So the court has in the past issued declarations, for instance, declarations which postulate that the implementation of the declaration requires legislation being enacted by Parliament.
Yes.
The right to a clean environment, for instance.
Yes.
The implementation is ultimately for Parliament to say health, education, which eventually the right to primary education found expression the Right to Education Act.
Yes, absolutely.
Or the
It became
right
a
to
constitutional
food.
right thanks to a certain declaration.
Or the
I
right
agree
to
entirely.
food, which eventually resulted in the enactment of a legislation.
I'm with you on that, Manoj.
Therefore, at its core, is a constitutional precept to say that the court cannot issue a declaration would not be correct. Equally, we take your point that don't go into an area where you declare a right to marry, because that's Mr. Dwivedi.
That was the intent. That was the intent. That was the intent. Manoj, let's first of all define what marriage is before we move forward. And Manoj, my Lord Justice, but your lordships, Manoj, let's look into that. Ultimately, what is marriage? Forget about, Manoj, the law, 1955 Act. Forget all that, Manoj. Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Thus far. It's a union, Malaj. Even if the 1955 Act were not there, Malaj, it's recognized within and without as marriage. When I say within, by two people, pay that union, and without by society. So there are two elements to it. Recognition within, recognition without.
Could you just elaborate on that a little bit?
Well, for example, I mean, as I said, in the absence of a law, this union of two people with all the sacramental vows is accepted by a large majority of society for thousands of years.
That's the recognition without.
Yes, that's the recognition without, right? And that's essential. That's essential.
So the recognition without, according to you, then is the social recognition.
Is the social recognition. Thus far, it applied to only heterosexual couples. But it's still a marriage. But a marriage which is gained acceptability over centuries. The union between sexual union between sexually people who are homosexuals or whatever is still a union. You can't say it's not a union. They have a sexual identity which is separate. It's involuntary.
Involuntary?
In the sense, well, it's involuntary in the sense that these are their sexual.
It's not a matter of choice.
Yes.
That's what they call as ascriptive.
Yes.
Yeah. See, in that
they have no choice in the matter. That's how it is physically.
It could be said of both in that sense.
Sorry?
Could be said of both sets.
Yes, of course. Of course.
But that apart, it is voluntary in the sense that they choose.
Of course. I don't mean.
Just like in this.
The manifestation is involuntary. Otherwise, it's of course a voluntary union. I don't mean that, Malas. It's consensual. It's voluntary.
Your sexual orientation may not necessarily lead you to a union.
That's right. It may not. It may not. That's what I'm saying, Malas. Therefore, we are not talking about sexual orientation here, which is what I was started with. We're talking about a sexual union. And we are trying to give that a name. That's what we're trying to do, Malas. That's why you'll also ask the question, what's a marriage?
Right.
Right? You give it a name. Now, they may consider that this is my marriage. Who can stop anybody? How can anybody stop them from considering that this is a marriage? Nobody can stop them. There are two people who decide that they want to live together. They live together for 10 years, 15 years. They say, I'm married to him. The moment you say now, without, you must recognize it, comes the problem. You may find it in 21, you may find it in 14, you may find it anywhere else. You may not find it in the Constitution at all. According to me, it's part of your right to be and to live as you please without interference from the outside world.